Hello students, welcome to KANISHKA IAS. Today we are going to discuss an interesting topic and which is equally relevant for the UPSC preliminary examination. Most of the people generally say that Indian constitution has strong legacy of the British rule. Indeed it is right. Why? Because Government of India Act of 1935 has strong impact on the constitution of independent India. Why? Because most of the provisions of the 1935 Government of India Act have been reproduced in the Constitution of India. But you will wonder, there is another legislation which is having equal impact on the Indian Constitution. That is none other than General Clauses Act of 1897. And you will also surprise that this particular legislation has been provided in the Constitution itself as a reference. For instance, Article 367. The Article 367 is such an article which assists the judiciary to interpret the constitution. Not only judiciary, if any organ of the state, as a matter of fact. For instance, in the legislature also, the speaker has the power to interpret the constitution for the legislative matters and legislative proceedings. That's how Article 367 is instrumental in the hands of the various institutions to define various terms of the constitution. And you must also know another important point. What is that? If Article 367 has to assist various agencies to define the terms of the constitution, every term must be given a proper glossary in the constitution itself. But in fact, constitution makers wisely did not provide that glossary and they have avoided that difficulty. Why? Because if you try to cram all the information into the constitution, the length of the constitution will become increased, and moreover, it will also become more complex for the various institutions to understand the constitution. That's the reason why cleverly under Article 367, the constitution makers have put in place the General Clauses Act reference, which means Article 367 assists in the interpretation of the constitution with the help of the General Clauses Act. Article 367 has initially 4 clauses. Let us discuss about these 4 clauses, then you will understand what is the essence of Article 367. First of all, before we understand Article 367, you must also understand what is interpretation. Interpretation means understanding the provisions of the constitution or any statute in a broader perspective. In other words, the contextual application of various provisions of the legislation or constitution is nothing but interpretation. So in order to interpret the constitution or any statute, definitely there must be clear meaning of every term provided. Moreover, in India, constitution cannot provide everything for the future governance. Definitely, the constitutional provisions must be given an effect by means of legislations, ordinances and various instruments. And of course, there will be a possibility of inconsistency in the meaning of provisions between legislations, statutes, ordinances as well as constitution. So there must be a binding glue across all these tools of legislation. For this requirement, the General Clauses Act of 1897 will provide a lot of help. So now, let us get into what is Article 367 and various clauses. Article 367 deals with various interpretations, and Article 367 clause 1 says, in order to understand the provisions of the constitution or the statute or any legislations, we need to take the help of General Clauses Act of 1897. In fact, this General Clauses Act of 1897 will provide a detailed description of every terminology that might be mentioned in any statute or any law. For example, in the General Clauses Act of 1897, they have made government means either central government or state government. Public officer means what is the meaning of public officer. That's how elaborate list has been provided in this particular act. And there was also a debate under Article 12 of the Constitution, which agencies generally come under. If you try to look into Article 12, what is a state? The state has been given different dimensions. That is central government, central legislature, state government, state legislature, local and other authorities. Then the pertinent question would be is, at the commencement of the constitution, what must be considered as a local body or local authority? Then the Supreme Court has taken the help of General Clauses Act of 1897 to interpret what is local body, right? You can understand the importance of this particular Article 367 and General Clauses Act of 1897. Moreover, Article 367 clause 2 mentions the importance of ordinance. Actually, you take any provision of the constitution. For instance, you take Article 21. What does it say? No person's personal liberty and life shall not be deprived except according to the procedure established by law. Then the term law, whether it includes ordinance or not, definitely that would be a matter of litigation. Hence, Article 367 Clause 2 says, for the purpose of understanding what is legislation, the ordinance must also be construed to be legislation. So it means wherever the term ordinance is seen, any act or any administrative directions, you need to interpret, you need to understand ordinance is nothing but law. So it means even by use of the ordinance, you can deprive the life and liberty of the individual. Similarly, you can also look at Article 300A, which says that the land shall be acquired only according to the law enacted by the legislature. So here also the law may also include ordinance. So that's kind of ambiguities are settled by Article 367 Clause 2 of the Constitution. But Supreme Court in various judgments said that ordinance, once it is lapsed, it does not come under the definition of law. So that kind of clarificatory explanation has been given by the Supreme Court by using its interpretative powers. Coming to Article 367 Clause 3, it defines what is foreign state. This is very important in fact. Why? Because India, after the independence, it had a special relationship with various countries. For example, Sikkim was a separate country, and Sikkim entered into a kind of friendly agreement with India. Sikkim was nothing but a protectorate state. So then Sikkim shall be considered as a foreign state or not. That becomes ambiguity. And moreover, after the independence, India had to have some relation with the Commonwealth nations. Okay, so these Commonwealth nations shall be having equal parity with the other foreign nations or not. That will become a question. Okay, in this context, the Article 367 Clause 3 will be helping the government of India to avoid unnecessary litigations, where India can be having special relation with other nations where they will not come under the strict definition of the foreign state. The definition of the foreign state can be diluted by the power of the president, that is by issuing orders, by issuing some notification stating that this country is having special relation with India. Okay, that will be avoiding unnecessary litigation with various aspects. Moreover, in Berubari Union's case, Supreme Court has examined whether Pakistan is foreign state or not. It has applied the meaning of Article 367 Clause 3, and it stated that Pakistan is not exempted as a foreign state. Hence, ordinary law cannot be the instrument to transfer the Indian territory to the Pakistan. Rather, we need to have constitution amendment. So that's how Supreme Court has utilized Article 367 Clause 3 to resolve the litigation pertaining to the transfer or ceding of the territory to the foreign nation. Moreover, Article 367 Clause 4, which talked about the citizenship at the commencement of the Constitution, which says that whoever had the domicile of India for 5 years before the enforcement of the Constitution, he will automatically become the citizen of India. That was provided under Article 367 Clause 4. Moreover, in the recent times, under the presidential order related to the Jammu and Kashmir, this Article 367 got into the light again, where we wanted to abolish the special status for Jammu and Kashmir. In order to abolish the special status to Jammu and Kashmir, we need to follow Article 370 Clause 3. Article 370 Clause 3 says, if the special status is to be abolished, Constituent Assembly of the Jammu and Kashmir has to give assent, apart from the presidential notification. Anyway, President can notify on the advice of Prime Minister and Council of Ministers. There is no problem. But whose consent is to be obtained? The Constituent Assembly's consent is to be obtained. But Constituent Assembly of Jammu and Kashmir, is it in the operation? No. So naturally that becomes a litigation. That's the reason why the President, by using his presidential order, has amended Article 367 by the inclusion of Clause 4. This Clause 4 says, Jammu and Kashmir Constituent Assembly must be considered to be legislative assembly. So you must also remember this fact. What is that? Article 367 talks about interpretations. So what 367 Clause 4 is interpreting? The Jammu and Kashmir Constituent Assembly must be constituted to be legislative assembly. And under Article 370 Clause 3, definitely the meaning changes, where in the absence of the Constituent Assembly of Jammu and Kashmir, legislative assembly can be giving the assent. Then what happened at that point of time? Since Jammu and Kashmir was under the presidential rule, the president himself acted as a legislature and given the assent. He himself has notified and he himself has given assent. That's how Jammu and Kashmir lost its special status. But of course, Supreme Court said that Article 367 cannot be amended that way by means of a executive order. executive order cannot be the means to amend various articles of the constitution. Hence, constitution amendment must be the way to amend the article 367. That is a different issue. But end of the day, what we must be able to understand is article 367 will be assisting the judiciary, legislature and executive to perform various constitutional functions. And moreover, article 367, by recognizing the General Clauses Act of 1897, is helping to find out the commonality across all the legislations, ordinances and other instruments of the state in sync with the constitutional provisions. And moreover, article 367, by taking the reference of the General Clauses Act, did not require to detailedly describe all the provisions of the constitution under this given article. So this avoided the duplication. And moreover, this kind of questions will be possible in the UPSC preliminary examination, because examiner will try to test your understanding of article 367, because of course this event or the relevant current affairs are not of this year, but of course the UPSC may also test your stock GK. In that context, aspirant must know this kind of information. Thank you. For more videos, please subscribe to KANISHKA IAS.